Good day, Crime Talk aficionados. We have a great show for you today. First, Lori Vallow doing her lawyering thing at the pretrial conference. And wait until you hear some of her notices of defenses and witnesses. A mistrial in the case of the judge who killed his wife, an Infowars reporter brutally murdered outside of his apartment, this day in legal history, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and yes, you can check us out anytime on any of your favorite podcasting apps. Now, it is Tuesday, which means we're going to go live tonight, 6 p.m. Mountain Time. Please join us. It's going to be an interesting show. We have a lot to talk about. Obviously, we got Lori Vallow. We've got Brian Koberger. And of course, we can talk about Karen Reed as well. Join us. It's going to be good. Trust me on this one. All right. Now, before we get to the docket, a couple of things. First, go to CrimeTalkSearch.com. Sign up for that background subscription service today. When you do, you'll be able to do a background search on as many people as you desire here in the United States. And the beautiful thing is you can cancel at any time, and you can do one report or you can do 1,000 reports. It doesn't matter. But let's say, for example, somebody's name showed up on a witness list on a high-profile case in Arizona. You could do a background search on all of those people, ladies and gentlemen, so that you can get the information. Who knows? Maybe the big scoop, too. Anyway, go to CrimeTalkSearch.com. You're going to be happy that you did. All right, let's go ahead and open the record for Tuesday, March 11th. First on the docket, ladies and gentlemen, Lori Vallow. That's right, Lori Vallow doing her lawyering thing pro se. Now, she didn't have a great day in court today. In fact, the judge ruled against her on several of her motions. Now, for those who are not familiar, Lori Vallow has 2 cases pending in Arizona. All right. The first case that's going to go to trial first is the conspiracy to commit the murder of Charles Vallow. It is alleged that back on July 11th of 2019, Charles Vallow, Lori Vallow's 4th husband, was shot and killed by her brother Alex Cox in Chandler, Arizona. And Cox claimed self-defense, stating that Charles attacked him with a baseball bat during an argument at Lori's home. No charges were filed against Cox at the time, and he died of natural causes, a blood clot, in December of 2019. Now, the prosecutors allege that Lori conspired with Cox to murder Charles as part of a broader scheme to remove obstacles to her relationship with Chad Daybell, husband number 5. Now, at the time of his death, Charles had filed for divorce in February of 2019, citing Lori's increasingly erratic behavior, including her claims of being a godlike figure tasked with ushering in a biblical apocalypse. He had also obtained a restraining order against Lori after she allegedly threatened to kill him. Now, prosecutors argue that the killing was premeditated, motivated by financial gain, a life insurance policy, and Lori's desire to marry Chad Daybell, whom she wed shortly after Tammy Daybell's death in October of 2019. So specific evidence details are somewhat limited, obviously, from what we know thus far, but the indictment from 2021 suggests prosecutors will rely on circumstantial evidence, such as Lori's communications with Cox and Daybell, her actions following Charles' death, for example, moving to Idaho, and the timing of subsequent events tied to her doomsday ideology. Her second case that is scheduled to go second, and Lori says speedy trial issues are running on this particular case, but the judge says not worry about speedy trial because I can't try both of these cases at the same time. So at the hearing today, obviously Lori remains in custody, and she is still classified as a high security inmate. Now she spends her time actively preparing for trial, representing herself, and challenging the prosecution's case. As of today, March 11th, 2024, 2025, Lori Vallow appeared in the Maricopa County Superior Court in Phoenix for a pretrial hearing ahead of her upcoming trial on the conspiracy to commit murder on her fourth husband, Charles Vallow. The hearing is about 20 days before the jury selection begins. It's scheduled to start on March 31st, 2025, and it was focused on several procedural matters as Lori Vallow prepares to represent herself at trial. What could possibly go wrong? What do they say? He who represents himself has a fool for a client. Well, a central issue was the presence of cameras in the courtroom, and the Judge Bareski, ruled that a single pool camera would be allowed to live stream the trial with a possible 1 or 2 minute delay, despite Lori Vallow's objections. She had previously filed a motion to ban cameras, citing concerns over media portrayal, such as court TV commercials she claimed to misrepresent her and her husband, Chad Daybell. Now, during the hearing, she expressed specific worries about cameras zooming in on her notes or her face excessively, requesting that coverage focus on the judge or the prosecution when they spoke. The judge assured the guidelines would be issued and forthcoming, and they would address all of Lori Vallow's concern. Another point of discussion today involved evidentiary matters. Lori Vallow argued for the admissibility of a police interview with her late brother, Alex Cox, the alleged shooter in the Charles Vallow case, claiming it didn't constitute hearsay because it wasn't offered for the truth of the matter asserted. The judge challenged her reasoning, asking if she wasn't implying the statements were true, to which she responded ambiguously, saying she couldn't confirm their veracity. This exchange highlighted her active engagement in legal arguments as her own counsel, supported by two advisory attorneys, Pamela Hicks and Robert Abernathy. Now, the hearing also touched on jury selection logistics. The judge outlined that 200 potential jurors from Maricopa County would soon receive electronic questionnaires with responses reviewed by both sides to narrow down potential jurors. Additional questionnaires could be sent out if needed, and in-person questioning is set to begin for the 12 jurors plus 3 to 4 alternates. That questioning will begin in early April, and opening statements are expected around April 7th, with the trial lasting up to 6 weeks. I can't believe it's going to take 6 weeks. It's like a 6-day trial anywhere else. Anyway, this hearing underscores Lori Vallow's legal battles in Arizona, where she faces charges tied to the 2019 shooting of Charles Vallow and a separate conspiracy charge for the October 2019 attempted murder of Brandon Boudreaux, her niece's ex-husband. Already convicted in Idaho of murdering her children and conspiring in Tammy Daybell's death, she remains a high-profile figure, with today's proceedings reflecting both her self-representation strategy and the court's efforts to balance the public access with the trial fairness. Her next court date is March 18th to address some additional issues. Now, Lori has also done some filings in her cases, and it is the Defendant's Supplemental Rule 15.2 Notice of Defenses and Disclosure. You must, in a criminal case, disclose any defenses to the court and to the prosecution, usually no later than 35 days before trial, so that you can, everybody's on notice and it's a fair trial. Just like in the Koberger case, they have to give their alibi up front because we don't want to prosecute an innocent person, right? Exactly. So you have to put everybody on notice. It's just the fair and right thing to do. Now, remember, Lori Vallow is charged with conspiracy. Conspiracy, which is an agreement between two or more people to commit an illegal act. And the defense to the conspiracy is there is no conspiracy. That's what you have to be able to show. Judge, I didn't conspire, and therefore I cannot be held responsible for the acts of another. They acted alone. So you would say general denial. And if there was, in fact, a conspiracy, the only other defense that you have that there was no conspiracy was, I was in the conspiracy, but I withdrew from the conspiracy and I shouted it from the mountaintops and said, I will not be involved in the death of Charles Vallow. I'm not aware of any of that. So really, the only defense is general denial, no conspiracy. Her opening statement should be, ladies and gentlemen, I have been wrongfully accused of a crime that I did not commit. There was no conspiracy. I didn't know my brother was going to kill Charles Vallow, my fourth husband, who, although we had our issues, I loved dearly, and I would never harm him in any way. What you'll hear is speculation and rumor on behalf of the prosecution witnesses, but they were not there. They don't know what took place in that house, but all we know is that I wasn't there and there was no conspiracy. And ladies and gentlemen, when you hear all the evidence in the case, you will conclude that there was no conspiracy either and find me, Lori Vallow, not guilty. That's all she has to say. But no, being the non-lawyer that she is, files the following Defendant's Supplemental Rule 15.2 Notice of Defenses and Disclosures. The defense notices the following defenses: insufficiency of the evidence, which is basically general denial. Self-defense. Lori Vallow wasn't there, so how can she claim self-defense? Defense of others? That would say that she did it. Third party at fault. Mere presence, which is it's basically mere presence is a jury instruction, and it says mere presence at the scene of a crime does not necessarily mean that you may have had anything to do with the crime committed. Okay, and then she filed, in one word, procedural. I have no idea what that means, ladies and gentlemen. She has stumped me. And then it gets even better. The defense notices the following potential witnesses. The defendant. Oh, she's going to testify. Ladies and gentlemen, this is going to be worth coming here to Crime Talk and watching, because she is going to testify. And every time she gets up and says something, she is basically going to be testifying. Then she endorses any and all individuals, including but not limited to victim assistants, caseworkers, and volunteers who have spoken with any witnesses in this case. Okay. All witnesses listed in the Rule 15.1 disclosure, as well as my supplemental filings. All right. The custodian of records for any and all exhibits. All right. Nate Eaton is a reporter with the Idaho News. He was not there at the scene of the crime back in 2019. I'm not sure what information he had, so I don't think he's going to be relevant. Valicia Istahua, Itaiahau. I mispronounced it. Beat me up already. Gabrielle Bonilla, Joseph Pongratz, Ashley Rand, RYND, Barry Cox, Zachary Cox, Adams Cox, Janice Cox, Summer Shislet, and Brandon Boudreau. Okay. And the defense notices the following documents, photographs, and other tangible objects that the defense intends to use at trial. Any items disclosed by the state, insufficiency of the state's evidence. I know she has advisory counsel that are helping her along the way, but she has to do those herself. Some of that makes absolutely no sense. But hey, what do I know, Lori? Although I just gave you your opening statement. Just saying. Next on the docket. A judge's trial for killing his wife ends up in a mistrial. That's right. A judge declared a mistrial Monday in the case of the Southern California judge charged for shooting his wife. Now, juries in Santa Ana could not reach a unanimous verdict in the case against the now 74-year-old Orange County Superior Court Judge Jeffrey Ferguson. Now, apparently, it's being reported that 11 of the 12 jurors had wanted to declare Ferguson guilty of at least second-degree murder. That one holdout. So now they get to do it again. Anyway, prosecutors charged Ferguson with murder, saying he shot his wife Cheryl with a handgun while the couple was watching a television at their home in Anaheim Hills after they were apparently arguing. Testifying in his own defense, the judge did not deny shooting his wife, but said it was simply an accident. Now, prosecutors alleged Ferguson had been drinking before he made a gun-like hand gesture towards his wife of some 27 years during an argument at a restaurant on August 3rd of 2023 over some family finances. They said he later pulled out a real gun when she chided him to do so after they returned home to watch Breaking Bad. And their son was also present there as well, their adult son, Philip. Anyway, Ferguson acknowledges firing the gun, but contended it was an accident when he was removing the gun from his ankle holster, where he always carried it, and tried to place it on the table, but oops, fumbled it. The case was heard in a courtroom about 10 miles from where the judge presided over criminal cases, as a judge which included extensive video footage of Ferguson talking to police outside his home after the shooting and after he was taken into custody. He was seen on video sobbing and saying his son and everyone is going to hate him. The case roiled the legal community there in Orange County, which is home to 3 million people between Los Angeles and San Diego. Now, the Los Angeles Superior Court, Judge Eleanor Hunter presided over Ferguson's case to avoid any conflicts of interest from other judges. Now, immediately after the shooting, Ferguson and his son both called 911, and Ferguson texted his court clerk and bailiff and said, quote, "I just lost it. I just shot my wife. I won't be in tomorrow. I'll be in custody. I am so sorry," end quote, according to the text that the jurors were able to consider. Now, the police said that they also found some 47 weapons, including the gun used in the shooting and more than 25,000 rounds of ammunition at the home. And prosecutors kind of relied upon that to say that the long-time former prosecutor had ample experience and training in operating firearms and in handling them, and therefore he couldn't have been fumbling the gun and it was an accident. He must have been guilty. My experience is some of the most experienced owners of weapons are sometimes some of the most careless individuals as well. Anyway, Ferguson became a judge back in 2015. He's currently not on the bench because, well, he can't be because he's facing felony charges, but at least he's getting his salary while he can't hear any cases. Now, Mr. Ferguson did begin his legal career as a DA back in 1983 and went to work prosecuting narcotics cases, where apparently he was quite good and received many awards. He is also the president of the North Orange County Bar Association from 2012 to 2014. Well, we'll see if they get to do it all over again. I would say yes when the verdict was 11-1. 11 for guilty, second-degree murder, 1 not guilty or couldn't decide. And they know exactly what he's going to say, so they'll do it again. If I was the judge, I'd be thinking plea bargain. Next, a reporter for Infowars. That's right. Infowars. Texas police are investigating a killing after an Infowars reporter was killed in Austin, Texas on Sunday night. Now, the Infowars founder, Alex Jones, announced Monday that one of his reporters, a guy by the name of Jamie White, was brutally murdered about midnight outside of his apartment. Now, the initial investigation shows that White was shot and killed in the parking lot of his apartment complex where he lived. The suspect then fled the scene. Detectives believe the suspects were possibly burglarizing White's car when he interrupted the burglary. And the Austin PD has not released any suspect description, but did ask that may have had their vehicle burglarized that night to report it to the police. This is being investigated as a homicide, the 8th homicide of the year so far there in Austin. Now, according to the police reports, officers arrived at the scene and found an adult male with an obvious signs of trauma. The victim was transported to a hospital where he ultimately died. Sad case of anybody getting killed while literally getting robbed. Next on the docket, this day in legal history, March 11th, 1927. The first armored car robbery. That's right. The Flatheads gang, led by Paul Jaworski, committed the first armored car robbery near Pittsburgh, Pennsylvania. The gang used explosives to halt 2 armored cars transporting payroll for the Terminal Coal Company, escaping with over $104,000. And on this date in 1977, Roman Polanski, that's right, the film director, Roman Polanski, was arrested in L.A. on charges of raping a 13-year-old girl. Now, the case obviously brought a lot of issues of sexual misconduct in Hollywood and led to ongoing legal battles, particularly when he fled to Europe. And then on March 11th, 1861, 7 former United States adopted the Constitution of the Confederate States of America, which closely followed the original United States Constitution language, if not necessarily the purported Section 9(4) of the Confederate Constitution, which read, "No bill of attainder, ex post facto law, or law denying or impairing the right of property in Negro slaves shall be passed," enshrining the right to own slaves as a fundamental law under the Confederate States. Obviously, we know how that turned out. Not so well. And finally, our dumb criminal of the day. San Luis Obispo police arrested an alleged drug dealer last month, whom they found intoxicated and lying on a sidewalk next to a large amount of drugs and cash. So it was about 11 p.m. on February 14th, and a caller reported a man bleeding from a cut on his head. Officers do what they do. They showed up, and they found the very intoxicated man lying on the ground next to a Louis Vuitton bag. What did the officers find in the Louis Vuitton bag? Well, they found some ID, $1,000 in cash, several cell phones, and a plastic bags with approximately 35.5 grams of a white powdery substance. And who was this man that was there? Angel Resenda of Avila Beach was taken to the hospital because of his high level of intoxication and treated for his injuries. And guess what? That unknown white powdery substance later turned out to be cocaine. Anyway, the San Luis Obispo Police Department authored a search warrant for the dumb criminals' residence and vehicles, which led them to discover, well, that's right, ammunition and more narcotics. Officers arrested the man for felony possession of a controlled substance, felony possession of narcotics with intent to sell, felony possession of narcotics with 2 prior convictions, and felony possession of ammunition by a convicted felon. It sounds like this is not his first rodeo. Anyway, Mr. Rezendev, guess what? You are a dumb criminal of the day. You know what? Is it because you were dealing drugs? No, sounds like that's your lifestyle. You're a dumb criminal of the day because every drug dealer knows, ladies and gentlemen, we're not condoning this, but anyone that's going to succeed doesn't use his own product. And apparently you drank and you're probably doing drugs and using your own product. Number 1 rule against anything that involves sin: don't use your own product. That's all we have for you today, ladies and gentlemen. Hope you enjoyed the show. Join us tonight, 6 p.m. Mountain Time for Tuesday Night Live. Join us. Remember, the Constitution matters.